first.
As I was saying, you pointed out that I was rubbing my eyes in the back. As hard as it is to believe, it really wasn't because I'm tired. It's because I'm just humbled by this entire proceeding. And there's just no way that I'm going to be able to provide anything closer to you that's as eloquent as even some of the testimony that you've heard. But I'll give it my best shot. As I proposed in the opening, Your Honor, I think the evidence has shown that the prosecution has failed to meet its burden to prove that the defendants acted with the intent to cause public inconvenience, annoyance, or alarm. If you look at the evidence, it clearly demonstrates that with respect to this focused time period after 4 o'clock on April 22nd of this year, individuals did in fact lay down in the driveway, and that arrest began at 4:11 on that day. And then by their own, prosecution's own witness statements, it was Senior Master Sergeant Reinhardt who's the only reference of any of the witnesses to there being any public inconvenience was his claim that at 4:18, 7 minutes after the arrest began, that he saw someone he believed was attempting to get on the base. So he clearly remembered that so many months ago that something occurred on 4:18. But when I asked him if it was what kind of vehicle it was it a car or a truck? Couldn't remember. Was it, what color was it? Couldn't remember. And then actually conceded or acknowledged that all he knew, that the vehicle was just slowing down to look at what was happening. So in terms of any evidence of public inconvenience, that's it. Now we heard arguments earlier by the prosecution that there was some inference of activity because personnel on the base had to be redirected to another exit for 11 minutes longer than they had been. So I submit that they have not proven that element. Furthermore, it was impossible for them to obstruct vehicular traffic on that driveway due to the security measures that both the law enforcement agencies and the air-based security had taken, setting up cones along the roadway with Malloy Road, closing the gate, filling up the portions of the driveway with police cars, and having the gate and the fence area manned by Air National Guard personnel. So that, I think, is how they've proved that they've failed to prove any of the elements of disorderly conduct. But second, and here's where anything that I might say or argue, again, would not be as eloquent as what you heard or what you're going to hear in closing. And I think you, in some of your remarks or questions, you were alluding to that you have to make a consideration of balancing laws. And if that's your interpretation of your duty in this regard, I ask you I respectfully ask that you do two things. One, that you give that decision or that consideration the same patient, thoughtful, and thorough approach that you have clearly afforded to this trial. And furthermore, that when you're making that weight or balancing, you must keep in mind that, as the evidence has shown, the protesters, however you want to characterize the protesters, civil resistors, were acting and their intentions were driven by their understanding of international law. And both, as it was delineated to you by Mr. Clark, Ramsey Clark, when he referenced the Constitution, Article 6, Section 2, it clearly says that the Constitution and the laws of the United States and all treaties made or which shall be made shall be the supreme law of the land. So that's the one side of the scales, if you will. And the other side of the scales is whether or not individuals were guilty of a disorderly conduct violation consisting of an 11-minute demonstration that required air-based personnel to be redirected for 11 minutes and hypothetically may have inconvenienced someone that the identity of which we don't know. So all I can do is reiterate that when you make your considerations and determinations, that you keep in mind which side of those scales represents the supreme law of our land.